My name is Serona Elton. I'm the head of educational partnerships at the Mechanical Licensing Collective, the MLC, and I'm also a professor of music industry at the University of Miami Frost School of Music. I'm going to talk to you about mechanical licensing and royalties. First, we have to cover off a couple of copyright basics. You might use the terms songs or compositions. The copyright law calls these musical works, and they're typically created by songwriters, composers, and lyricists. And the business of songs is usually handled by a music publisher. And here we're talking about the music, meaning the melody, harmony, rhythm, lyrics, if there are any, that could be expressed in a system of musical notation, such as on sheet music, for example. A really famous song you might have heard of is called Yesterday by John Lennon and Paul McCartney. Keep that example in mind. Musical works are separate from recordings, or what the copyright law calls sound recordings. And these are created by recording artists and producers when we're talking about the music industry, typically distributed by record companies. And these are comprised of sounds only, not a visual image. If we're talking about a recording that includes a visual image, then we're talking about an audio-visual work, which is what the copyright law calls videos. And those are a third kind of creative work that is protected by copyright. So a sound recording is just of sounds. And in the music industry, it is usually the sounds of a musical work. Certainly you could have an audio book, which is not of a musical work, or a podcast, for example. But a sound recording of a musical work is what we're usually dealing with in the music industry. Building on that example, the first time that song by John Lennon and Paul McCartney was recorded was by the Beatles, but then it was recorded by Aretha Franklin, Frank Sinatra, Elvis Presley, and thousands of other recording artists. So we have one song recorded by many different artists, resulting in many different sound recordings. Mechanical licensing lives at the intersection of the song and the sound recording of that song. So if you happen to be the owner or of the copyright in a musical work, the copyright law grants you a set of exclusive rights. That's what it means to own the copyright. And these are things that, for the most part, you have control over, although sometimes the law takes that control away from you. And we'll talk about that in a second. But those rights include the right to control reproductions of your work, distributions of the work, public performances of the work, public displays of the work, and the preparation of derivative works, meaning other creative works that incorporate your musical work into them somehow. We could connect all these different exclusive rights under copyright law to the different ways that people use music. So, for example, when we're talking about reproducing and distributing a musical work, that might be an example in sheet music. That would be a reproduction and distribution of a musical work. A CD or vinyl record is an example of a reproduction and distribution of a musical work. So is an interactive stream. An interactive stream is an on-demand stream where you, as the person using that platform, like Spotify or Apple Music, you get to go and pick the exact recording you want to hear. You're in charge. That makes it an interactive stream. And downloads are all examples of reproductions and distributions. And when we say mechanical licensing and mechanical royalties, what we're talking about when we use that terminology in the US is the reproduction and distribution of a musical work into a sound recording, and then that sound recording being available as CDs and vinyl records, interactive streams, and downloads. Just to finish out some other uses of terminology, examples of, public performance. Actually, before we get to that, the MLC, the Mechanical Licensing Collective, a new organization that is created to handle one particular kind of mechanical licensing. When we talk about the MLC, we are only talking about interactive streams and downloads. The MLC was created by a change in the US copyright law that went into was signed into law in 2018, and the new way of doing things went into effect in 2021. And the MLC was created very specifically to do this new kind of mechanical licensing process that only applies to interactive streams and downloads. So just some other examples, public performance, live shows, FM radio, interactive streams, and non-interactive streams. Non-interactive streams are like digital radio, for example, or satellite radio. Those are public performances. And so actually you might notice that an interactive stream is a reproduction, a distribution, and a public performance. A public display of a musical work might be having the lyrics show up on a billboard, for example. And some examples of preparing derivatives would be a synchronization use, an interpolation use, and sometimes people call that sampling of that song into another song. Remixes, arrangements, translations would all be examples of derivative uses, derivative works of that musical work. So let's get into a little bit of mechanical licensing terminology. So one of the things that you want to keep in mind is that the way we handle this in the US is we have sort of two alternate approaches to this. One approach involves a voluntary, which means no one's forcing you, right? It's optional, voluntary direct license between a music publisher or an agent they might have hired to do this on their behalf and the party that needs a mechanical license, like a record label or a digital service provider, which is another word for those services like Spotify and Apple Music. So in the case of a voluntary direct license, you have that licensee, the record label or digital service, negotiating directly with a music publisher or some agent that they have designated to handle this on their behalf. An example would be the Harry Fox agency. Voluntary means that no one is forcing them to do this, and they are directly negotiating the granting of this permission. Permission is just another word for license. But what we also have in the United States is a compulsory license. And in a compulsory license, you have the law itself granting the license. The law says you are allowed to use music in this way so long as you follow a bunch of rules. And those rules are found in the federal law and related federal regulations. So we actually have a combination of voluntary licensing and compulsory licensing in the US when we're talking about mechanical licensing. Another thing to know about terminology is the difference between a work-by-work license or work-by-work licensing model. And really, this is a share-by-share model. So for example, what this means is that the party that wants to use that musical work, let's say they want to get a mechanical license to make a record of that musical work, if they're following the work-by-work model, then they have to research who are all the songwriters of the song that they're making a recording of. They have to find out who is handling the publishing for each of those songwriters. And then they either have to approach that publisher for a voluntary license, or if this use is even eligible to fall under the compulsory licensing approach, they have to send them a notice of intention to rely on the law. So work by work licensing is really another way of saying like one at a time, one by one. And you have to do it if you're trying to get a license for a mechanical use of a particular musical work. You have to do this with each of the different people who are writers and publishers of that song. Meaning, let's say you had 4 co-writers and they each have a separate publisher. You as the record label would be approaching all 4 publishers. You have to go to each one of those publishers who could grant that license on behalf of their respective writer. But so we have a different approach now, thanks to this change in the law. We now also have something called a blanket license for mechanical licensing. This only applies to digital music services. Record labels still have to follow this work-by-work model, but digital music services can now get a blanket mechanical license, which means that they're not getting this on a one work at a time basis or for one publisher of a work at a time basis. They get one license, and that grants them permission to use tens of thousands, hundreds of thousands, millions of works, whichever musical works are eligible to be included under that license based on the criteria that are outlined in the law. So we have work-by-work licensing as an approach, and we have blanket licensing as an approach. Okay, a little more terminology. So we also need to understand what is a first mechanical use. The first time, this is the first time that a musical work is going to be basically turned into a sound recording, right? You're going to perform it and create that sound recording. And then that sound recording is going to be distributed to members of the public as an audio only physical record like CD or vinyl, and the copyright law calls those phono records, or as a digital record. The copyright law calls those digital phono record deliveries. And examples of those digital phono record deliveries are an interactive stream, a permanent download, or a limited download. Let me explain quickly the difference between a permanent and limited download. So with a permanent download, you buy that recording, it's yours forever, right? You can see it in your file list on your device. With a limited download, you're only able to perhaps play it a certain number of times or access it for a certain time period. A common example of a limited download is, let's say you're a Spotify premium subscriber and you want your playlist available for offline listening, meaning you want to be able to stream even though your device is not connected to the internet in any way. So when you press that button for your playlist to be available that way, what actually happens is that the music is downloaded to your device, but it's got a big long temp name that you'll never be able to find in your file list, and you can only listen to it as long as your subscription is still active. So that's an example of a limited download. So all of these uses, physical records and digital records in any of these formats, the first time a song is going to be made into a sound recording, and then that sound recording is going to be made available in one of these ways to the public for their private use. And so, for example, that means people who are using Spotify or buying records. But let's say you were going to be digitally transmitting that recording to restaurants for them to play it in their place of business. That would not be an example of to the public for their private use. So if these conditions are met, we're taking a musical work, making a sound recording, we want to make it available in one of these ways, and this is going to be for the public for their private use, then we call that a first use mechanical. That is separate and different from the second or later mechanical use. So this is really the second or later time that those activities happen. And there's two scenarios where this comes up. One are what we call cover records. So, for example, that song Yesterday by John Lennon and Paul McCartney, first recorded by the Beatles. That was the first mechanical use, was by the Beatles for the first physical product that was put out for the Beatles. But then when Aretha Franklin, Elvis Presley, Frank Sinatra, when they all also made recordings of that same song, those were examples of cover records. Those were second or later mechanical uses. And another example of a second or later use is a change in the format of the product. So the very first time that Beatles record was released, it was probably on vinyl, but then along came 8-track and cassette tape and then CDs. And so even though those were not cover records, it was still the Beatles recording. Each time one of those other kinds of products was put into the marketplace, that was also an example of a second or later mechanical use. A little bit more about that compulsory license that I mentioned. In the US, Section 115 of the US copyright law creates a compulsory license for the reproduction and distribution of a musical work into a sound recording that is distributed as a physical or digital record. And when that happens, the law grants the license. If you're relying on a compulsory license, it means the law grants the license. We don't have the owner of the copyright negotiating with the party that wants the license, right? A compulsory license means the law grants the license. And it's heavily regulated by the law and the regulations about what all those rules are and eligibility requirements for when is a work now eligible for compulsory licensing, okay? And the rules, by the way, are different for record labels as opposed to digital music services, those digital service providers, DSPs for short. There are different rules that apply to record labels than apply to digital services. For example, the digital services can use and rely on the blanket compulsory license. The blanket license is not available to record labels. Record labels have to follow that work by work licensing model. And there are royalty rates that are set by a panel of 3 federal court judges called the Copyright Royalty Board. Whenever you are talking about a compulsory license, and because you don't have the rights holder and the licensee seeking that license, they're not negotiating royalties. So whenever you have a compulsory license, you also need to have a statutory royalty rate that gets set by these judges and put into the federal regulations. And that is the royalty rate that the party relying on that license has to pay. Okay, so let's talk a little bit more now about who has the responsibility for securing these licenses and paying these royalties. Now, we are going to see that the answer to that question differs whether we're talking about that first mechanical use or a second or later mechanical use. We have different answers. Let's talk about interactive streaming and limited downloads. So if this is the first time a song is being turned into a sound recording, and then that sound recording is going to be made available as an interactive stream or limited download on services like Spotify or Apple Music, here's what has to happen. The first thing is the record label has to secure a direct voluntary license from the music publisher. That is the beginning of the mechanical licensing process for interactive streaming. Only after the record label does that and secures that first use mechanical license, then the digital service can do one of two things. Either one, they can rely on the blanket compulsory license that they operate under, and they're good to make that song available as a recording up there on their streaming service after that record label first gets permission from the music publisher to make that recording available in the first place. Or if the digital service wants, it can decide to negotiate directly with that music publisher and enter into a direct voluntary license. For the most part, the digital services are relying on the blanket license for most of the music up on their services. But for some of the largest rights holders, like the major music publishers, in some cases, those digital services have negotiated directly with those major music publishers. But let's say this was the second or later mechanical use. In this case, the record label does not need to obtain a mechanical license because they don't have to do this for streaming. As long as that first use license was obtained the first time around, now this work is eligible to fall under the blanket license. So if, let's say, a record label is going to put out a cover record, or has already released that record on physical products, the record label does not have to secure a mechanical license. The digital service has the same two options that it had under that first use scenario. It can either rely on the blanket license that's granted to it by the law, or it can obtain a direct voluntary license. And then the flow of money for interactive streaming mechanical royalties, depending on the choice the digital service pursued, was either the DSP, that digital service, is going to pay the MLC, and then the MLC will pay the publisher, and then the publisher pays the songwriter, or the DSP can pay the publisher directly, or sometimes the publisher might have designated an agent that it wants to collect this on their behalf, like the Harry Fox agency, for example. So you might have the digital service paying that agent, the agent would pay the publisher, and then the publisher would pay the songwriter. So the money can flow in two ways. The majority of the money is flowing to the MLC, that new organization that I mentioned a couple of slides ago. So let's talk about downloads. Permanent downloads, there's actually two different ways that this can be handled. The first way is where the digital service, that DSP, they are going to take on the responsibility for securing that permanent download mechanical license. If they're approaching it that way, and it's up to the service to decide which of these two ways it wants to go. If the digital service decides that it will handle this, then for a first mechanical use, it's the same that we just looked at. The record label still has to obtain that first use mechanical license, but after they do that, now that digital service can rely on the blanket compulsory license for their making that song available as a recording for download, or they could obtain a direct license directly from the music publisher if they want to, but the record label still has to kick the whole thing off by getting that first use mechanical license. If it's the second or later use, then same as we just talked about, the record label does not need to obtain another license because the digital service license, that if it's relying on the blanket, will basically encompass this use, or that digital service could again decide to get a direct voluntary license from the publisher, whichever that service chooses. And then that money flows either if the digital service, if they're going to rely on the blanket compulsory license, then that digital service is going to pay that money to the MLC. The MLC will pay the publisher, and then the publisher will pay the songwriter. Or if that digital service is going to do a direct deal with that music publisher, then that digital service will pay that publisher directly, or might pay some agent that the publisher has designated to collect that on their behalf. Either way, once the money goes to the publisher, then the publisher pays the songwriter. I will also just say, for songwriters who don't have a music publisher, they are what we call self-published or self-administered, and it means they're acting as their own music publisher. And so they can collect this money directly from the MLC as if they were a publisher, because they are a publisher. If you have another scenario where the digital download service is going to rely on the record label to secure the mechanical license and then pass that permission on to the digital service, then this is what this third column, how that works. So in this case, you have the download service for a first mechanical use, right? You still have the record label needing to get that voluntary direct license. That hasn't changed on any of these columns, right? And then the digital service will rely on that license that the record label got, right? In this case, the blanket license is not playing a role in this. The record label is securing the license, and the record label can only do a work-by-work license. The blanket license is not available to the record labels. So in this case of the digital service relying on the record label to handle the mechanicals, record label obtains a voluntary direct license, and then the digital service relies on that license. If it's a second or subsequent mechanical use, the record label has a choice. They can obtain a direct voluntary license, just like they did for that first use. Or since now it's the second or subsequent use, the record label could obtain a compulsory work by work, like one at a time, could obtain a compulsory mechanical license. Either way, the digital service is still relying on the record label to get that license. And so the flow of money in this case goes from the digital service to the record label, and then the record label pays the publisher the mechanical royalties or the publisher's agent. And then ultimately the publisher will pay the songwriter. And then the last one here for physical products, first use, you guessed it, the record label still has the obligation to secure that direct voluntary license. In all first use cases, the record label has to obtain that permission. But then there is no blanket license and there's no digital service involved because this is physical products. If it's the second or later mechanical use, the record label has a choice. They can get that direct voluntary license, which is really how most mechanical licensing for physical products works. It's usually the result of a direct voluntary license, not a compulsory license, even if that is an option. Or the record label could instead choose that option B and obtain a compulsory license. And the way the money flows there is the record label will pay the publisher or the publisher's agent, and then the publisher will pay the songwriter. I know this is a lot to absorb, so feel free to rewind and watch this video a couple times. This is a short video, but there's a lot of information right here. Lastly, I just want to leave you with a little bit more information to help you get any answers you might be seeking. Feel free if you have any questions about mechanical licensing, especially as it pertains to digital uses like downloads or interactive streaming in the US. You can visit the website of themlc.com, and we have several sections of great information, frequently asked questions, a resources section, and a how it works section. We also have a YouTube channel full of recordings of webinars, helpful how-to videos, and even some cool animated videos. So check out those resources, and we'll be seeing you.